The United States Supreme Court is supposed to be the final word on constitutional law. When 9 justices unanimously agree on something, lower courts are expected to follow those instructions. But what happens when a federal appeals court appears to simply ignore a Supreme Court ruling and does whatever it wants anyway? That's not a hypothetical question anymore. It's happening right now in a case that involves deadly force, the Fourth Amendment, and the question of whether police officers can be held accountable when they shoot fleeing suspects. This case has already been to the Supreme Court once, resulted in a rare 9-0 unanimous decision, and was sent back down with very clear guidance. Yet the lower court that received those instructions has issued a new ruling that seems to preserve the exact outcome the Supreme Court told them to reconsider. Now, this case may be heading back to the Supreme Court again, just months after that first ruling, and legal experts are watching closely because what happens next could determine whether Supreme Court decisions actually carry the weight they're supposed to. If lower courts can find creative ways to reach the same conclusions the Supreme Court rejected, then the entire structure of American judicial authority starts to crumble. This isn't just about one tragic shooting or one police officer. This is about whether the Constitution means what the Supreme Court says it means, or whether regional courts can effectively veto those interpretations by simply rewording their opinions. The story begins with a routine traffic stop that turned deadly in just seconds. A police officer pulled over a man named Ashton Barnes for what appeared to be unpaid toll violations connected to a rental car. Cameras had captured the vehicle passing through toll booths without payment, and the officer initiated a stop based on those violations. These were minor infractions, the kind of thing that normally results in a ticket or a court summons, nothing more serious than that. When the officer approached and ordered Barnes to step out of the vehicle, Barnes initially seemed like he was going to comply. He opened the car door as instructed, but then something changed. Instead of exiting the vehicle, Barnes suddenly tried to drive away. The officer, reacting in that split second, made a decision that would end up before the nation's highest court. He jumped onto the side of the moving vehicle, holding onto the door frame or window ledge. With the car now in motion and the officer clinging to the side, he drew his firearm. While still hanging on the outside of the moving vehicle, the officer fired 2 shots at Ashton Barnes. Both bullets struck Barnes. The car came to a stop shortly after, but Barnes had been fatally wounded. From the moment Barnes started to drive away to the moment the shots were fired, approximately 5 seconds had elapsed. 5 seconds that would generate years of litigation and 2 separate trips to the Supreme Court. The family of Ashton Barnes filed a lawsuit against the officer, claiming excessive force and a violation of the Fourth Amendment's protection against unreasonable seizures. The Fourth Amendment doesn't just protect against illegal searches, it also protects against the government using unreasonable physical force to seize a person, and deadly force is the ultimate seizure. The question in this lawsuit was whether the officer's decision to shoot Barnes twice while he was trying to flee in his vehicle constituted excessive force under the circumstances. The case went to federal district court, and that court had to decide whether the officer should be protected by qualified immunity or whether the family's lawsuit could proceed. To make that determination, the district court applied something called the moment of threat rule. Under this rule, courts are supposed to look only at the specific moment when the officer used deadly force and ask whether the officer faced a threat of serious harm at that exact instant. Everything that happened before that moment, all the context and decisions that led up to it, get set aside. The question becomes very narrow. Was the officer in danger right when he pulled the trigger? Using that framework, the district court ruled in favor of the officer. The reasoning went like this. At the moment the officer fired his weapon, he was clinging to the side of a moving vehicle, and if he fell or was thrown from that vehicle, he could suffer serious injury or death. Therefore, he faced an imminent threat, and the use of deadly force was justified. The lawsuit was dismissed. The Barnes family appealed to the Fifth Circuit Court of Appeals, which covers Texas, Louisiana, and Mississippi. That court reviewed the case and applied the same moment of threat rule. They looked at the split second when the officer was on the side of the moving car and concluded that he was in danger at that moment. They upheld the district court's decision and ruled in favor of the officer. The Fifth Circuit's reasoning was that the threat to the officer was real and immediate when he fired, and that was all that mattered. The family's attorneys argued that this was the wrong way to analyze the case. They said the court should have considered how the officer got into that dangerous position in the first place. Did he create the danger by choosing to jump onto a moving vehicle? Could he have let the car go and pursued Barnes in other ways? Was the initial traffic violation serious enough to justify this level of force, even if the suspect was fleeing? The Fifth Circuit said those questions weren't relevant under the moment of threat doctrine. What mattered was the snapshot of danger at the instant force was used, and nothing else. With that ruling against them, the Barnes family took the extraordinary step of asking the United States Supreme Court to review the case. Most cases never make it to the Supreme Court. The justices receive thousands of petitions every year and only agree to hear a small fraction of them. But this case raised an important question about how excessive force claims should be analyzed, and the Supreme Court decided it was worth their attention. They granted review. When the Supreme Court issued its decision, the result was stunning in its clarity and unanimity. All 9 justices, across the entire ideological spectrum, agreed that the Fifth Circuit had applied the wrong legal standard. The court's opinion rejected the moment of threat rule completely. The justices said that excessive force claims under the Fourth Amendment must be analyzed using the totality of circumstances, not just a frozen snapshot of one moment in time. The court explained that you cannot understand whether force was reasonable unless you look at everything that led up to it. Did the officer create the danger through his own choices? Was there an alternative way to handle the situation? How serious was the underlying offense? What was the threat level before the officer took action? All of these factors matter, and artificially limiting the analysis to one split second gives an incomplete and potentially misleading picture. The Supreme Court emphasized that officers cannot manufacture a dangerous situation through reckless or unreasonable actions, and then claim they were justified in using deadly force because of the danger they themselves created. That would give officers a blank check to escalate situations and then shoot their way out of them. The Fourth Amendment requires more careful analysis than that. This was not a close decision. This was not a 5-4 split with a narrow majority opinion and a passionate dissent. This was 9-0, as unanimous as Supreme Court decisions get. The message to the Fifth Circuit was clear. You applied the wrong test, you need to redo this analysis using the correct legal framework, and you need to consider all the circumstances, not just the final moment. The Supreme Court vacated the Fifth Circuit's judgment and sent the case back down for a new decision consistent with this guidance. Here's where things get controversial. After receiving that unmistakable instruction from the Supreme Court, the Fifth Circuit had several options for how to proceed. They could have asked the parties to submit new briefs addressing how the totality of circumstances standard should apply to these specific facts. They could have scheduled oral arguments to hear from both sides about what the Supreme Court's ruling meant for this case. They could have requested additional evidence or analysis about the officer's decision-making and the available alternatives. They did none of those things. Instead, the same panel of Fifth Circuit judges that issued the original decision simply issued a new opinion. They did not seek new briefing. They did not hold oral arguments. They essentially reconsidered the case on their own, applied what they called the totality of circumstances test, and reached the exact same conclusion they had reached before. The officer won again. How did they justify this? The panel's new reasoning was that anytime a suspect flees in a vehicle, that flight automatically creates a deadly threat. A moving vehicle is a dangerous instrumentality, they said, and anyone fleeing in a car poses a risk of harm to the officer and to the public. Therefore, even under the totality of circumstances approach, the use of deadly force was reasonable. The practical effect of this reasoning is to create what's called a per se rule. A per se rule means that a certain fact pattern automatically leads to a certain legal result, with no need for case-by-case analysis. In this instance, the Fifth Circuit's logic suggests that vehicle flight equals deadly threat, equals justified lethal force, almost as a matter of automatic application. That sounds an awful lot like the moment of threat approach the Supreme Court just rejected, just dressed up in different language. The Barnes family's attorneys immediately recognized the problem. They filed a petition asking for the full Fifth Circuit to review the panel's decision. In the federal appeals courts, cases are normally heard by 3-judge panels, but parties can request what's called en banc review, where all the active judges on that circuit consider the case together. En banc review is rare and is typically reserved for cases involving important legal questions, or where a panel decision conflicts with Supreme Court precedent or prior circuit precedent. The Barnes attorneys argued that this case met those criteria. They told the Fifth Circuit that the panel's new decision conflicted with what the Supreme Court had just said. The Supreme Court rejected bright-line rules and snapshot analysis. The Supreme Court demanded individualized consideration of all circumstances. But the panel had essentially created a new bright-line rule that says fleeing in a vehicle justifies deadly force. The petition also argued that this creates dangerous precedent. If officers know they can use lethal force against any fleeing driver, that gives them tremendous power with very little accountability. It means more shootings, more deaths, and less incentive for officers to use de-escalation tactics or less lethal methods of apprehension. Despite these arguments, the Fifth Circuit denied their request for en banc review. More troubling, no judge on the Fifth Circuit even asked for a vote on whether to grant en banc review. Normally, when a case raises serious concerns, at least some judges will vote to rehear it or will request that the full court vote on the issue. Here, there was nothing. No judge requested a vote. No explanation was provided. The panel's decision stood, and the case was closed at the Fifth Circuit level. The mandate issued, which is the formal process of sending the case back to the district court and ending the appeals court's involvement. That development sets up a potential return trip to the Supreme Court. And this time, the issue won't just be about the legal standard for excessive force. It will also be about judicial compliance with Supreme Court authority. There's another recent case that makes this tension even more relevant. Just recently, the Supreme Court issued another unanimous decision in a case called Vance versus Montana Challenge. That case didn't involve police shootings or the Fourth Amendment. It involved a different area of law entirely. But the principle the court announced applies directly to what's happening in the Barnes case. In Vance, the Supreme Court made clear that state courts and lower federal courts are not free to reinterpret, narrow, or water down Supreme Court precedent. When the Supreme Court announces a legal rule, lower courts must apply that rule faithfully. They can't twist it or find creative workarounds to reach the outcome they prefer. The Vance opinion specifically warned against what it called complying in name only. That's when a lower court claims to be following Supreme Court precedent, but actually applies reasoning that contradicts or undermines that precedent. The court said that's not acceptable. If a lower court reaches the same result by repackaging the very reasoning the Supreme Court already rejected, that's not compliance. That's defiance. The Vance decision was also non-narrow, which underscores how seriously the Supreme Court takes this issue. When lower courts don't follow Supreme Court guidance, it creates confusion in the law, undermines uniformity across the country, and forces the Supreme Court to step in repeatedly to correct the same court on the same issue. That's a waste of judicial resources and a failure of the hierarchical structure that's supposed to make the legal system work efficiently. Now, apply that principle to Barnes versus Felix. The Supreme Court issued a 9-0 decision rejecting the moment of threat rule and requiring totality of circumstances analysis. The Fifth Circuit panel, after remand, issued a new decision that effectively creates an automatic rule for vehicle flight cases. That looks a lot like repackaging the rejected reasoning. The panel didn't genuinely engage with the Supreme Court's guidance. They didn't conduct the kind of individualized, context-sensitive analysis the Supreme Court demanded. They found a different path to the same destination. If the Vance standard means anything, it means the Fifth Circuit's approach in Barnes is problematic. The Supreme Court told them to consider all circumstances and avoid bright-line rules. The panel appeared to do the opposite. They created a new per se rule that fleeing in a vehicle justifies deadly force, which negates the need for careful case-by-case evaluation. That seems like textbook compliance, in name only. So what happens next? The Barnes family now has until the end of this month to file a petition asking the Supreme Court to take up the case again. If they do file, they'll argue that the Fifth Circuit defied the Supreme Court's instructions and that the court needs to step in again to ensure compliance. They'll point to the lack of new briefing, the lack of oral argument, and the similarity between the panel's original reasoning and its new reasoning. They'll cite Vance and argue that the Fifth Circuit is doing exactly what the Supreme Court said lower courts cannot do. The Supreme Court will then have to decide whether to grant review a second time in the same case. Normally, the court is reluctant to take a case more than once. It suggests the lower court didn't get the message the first time, and it's an inefficient use of the court's limited docket space. But there are strong reasons to think the court might take this case again. First, the original decision was 9-0, which shows the issue was important and clear enough to unite all 9 justices. Second, the Fifth Circuit's handling of the remand raises serious questions about judicial compliance that go beyond this one case. If the court lets this slide, it sends a message that lower courts can find ways around Supreme Court rulings without consequence. Third, the Vance decision shows the court is paying attention to this problem and is willing to address it directly. Taking Barnes again would be a chance to reinforce that message in a concrete, high-profile case. If the Supreme Court does grant review, the question will be whether the Fifth Circuit actually applied the totality of circumstances standard, or whether they engaged in the kind of creative reinterpretation that Vance prohibits. The court will look at whether the panel considered all relevant factors, whether they gave genuine weight to the circumstances leading up to the shooting, and whether their vehicle flight rule is consistent with individualized Fourth Amendment analysis. And if the court concludes the Fifth Circuit didn't follow instructions, they'll have to decide what to do about it. They could reverse again and issue an even more detailed opinion explaining what totality of circumstances means. They could remand with instructions to a different panel or suggest en banc consideration. They could even take the unusual step of addressing the case on the merits themselves rather than sending it back down again. This case is no longer just about whether one police officer used excessive force during one traffic stop. It's now about the architecture of American judicial authority. Can the Supreme Court effectively supervise lower courts, or can those courts find ways to preserve their preferred outcomes despite clear guidance from above? This matters because the federal court system is hierarchical by design. District courts are bound by circuit courts, and circuit courts are bound by the Supreme Court. If that hierarchy breaks down, you get inconsistency, confusion, and forum shopping, where outcomes depend more on which court you're in than on what the law actually says. It also matters because constitutional rights depend on courts following the rules. The Fourth Amendment's protection against excessive force only means something if courts faithfully apply the standards the Supreme Court sets. If courts can manipulate those standards to reach predetermined results, then rights become meaningless. Officers won't have clear guidance on when force is permissible, and victims of unconstitutional force won't have meaningful remedies. Beyond this specific case, the pattern is concerning. If the Fifth Circuit can do this in Barnes, what's to stop other circuits from doing the same in other cases? What's to stop state courts from finding creative ways around Supreme Court rulings on abortion, gun rights, free speech, or any other contentious issue? The Vance decision suggests the Supreme Court is aware of this risk and wants to prevent it, but awareness isn't enough. The court needs to follow through with enforcement when lower courts step out of line. The Barnes family's decision to seek Supreme Court review again will be a test of that enforcement. If the court grants review, it signals that judicial compliance is a priority and that lower courts can't simply ignore instructions. If the court denies review, it suggests they're willing to tolerate a certain amount of creative interpretation by lower courts, even when it seems inconsistent with their guidance. Either way, the decision will have implications far beyond this case. For now, the clock is ticking. The Barnes family has until the end of the month to file their petition. Legal observers, civil rights advocates, and court watchers are waiting to see what they do and how the Supreme Court responds. This case has already made history once with a unanimous ruling. It may be about to make history again by forcing the Supreme Court to confront the question of what happens when its authority is challenged, not by defiance through resistance, but by defiance through creative reinterpretation. The outcome will shape how constitutional law works in America, whether Supreme Court decisions are truly final, and whether the rights enshrined in the Constitution receive consistent protection regardless of where you live or which court hears your case. That's why this case matters, why it's being watched so closely, and why the next few weeks could be pivotal for the American legal system. The Supreme Court spoke unanimously. The question now is whether anyone is actually listening.